Like, if you don't mind, Your Honor.
Sure. You don't want to get the New Hampshire flag too?
That's in there. You're surrounded by justice.
Beautiful. Okay, so this is Discover Bank versus Robert Tanguay, 24 SC 1960. Could you just state your names again, please?
Sure. Good afternoon, Your Honor. Ed Dial for Discover Bank.
Is it Ed Doyle?
Dial.
Dial? Okay. Did you file an appearance in this case?
No.
Would you please file an appearance in this case? I have Montgomery.
Yeah. Oh, okay. Pio and I work in the same office.
Oh, okay.
So,
Great.
Thank you.
All right. And you, sir?
Yes, Your Honor. Robert Tanguay, defendant. Pro se.
All right. Thank you. You can both have a seat. So we do have a motion pending. It was titled a motion to continue. When I read it, correct me if I'm wrong, but it seemed more like a motion to dismiss. I think that was the relief that you were really asking for. If I read it correctly, your theory was that under Article 3, the compromise between rights and authority is void if a person is held outside the law, right? And I think that's what you were saying that in the case of 2022, that you weren't given the protection of the laws, and therefore the bargain is void as it relates to you, and that Discover Bank's relief is to go against the state, not against you. Is that the theory?
Yes, Your Honor, and I really do appreciate that articulation. It shows that you read it. In addition, it is a report of judicial and professional misconduct in this court. The underlying issue, which is the Article 3, is that I've been held outside the protection of law with fraud in this court by Attorney Ames, and then through this court with the people that were mentioned in the Superior Court. Currently, I'm in appeal with intense deadlines for the Superior Court case, which I did file with that, and then I still have other claims that are involving in that. So what I'm asking the court to do is to review that motion and then put it into some sort of, as the court sees fit, what their duties are, and put some sort of written notice on. I'm saying that fraud and notice of judicial and professional misconduct to an attorney, 311:6, and also Rule 38, 2.15, the preamble for 38 for the clerk, supersedes. So anything else, in addition, though, I did speak to Mr. Dial, who's a gentleman. He has assented to continue this, and we can review it, and he will work with me because perhaps his heart was moved, and that's what I have to say.
All right.
Thank you.
And you can remain seated. It's a small claim, so it can be a little less formal.
Thank you.
I did also see in your motion, and I appreciate that there's an assent to continue, but in the interest of putting the case on the right track. In the motion, you also asked for the opportunity to request a jury trial in the Superior Court and to file a cross-claim. When reviewing the file, I saw that this default was based on a failure to answer. It was vacated, but when it was vacated, there was never established a deadline for answering. And when you answer the form that we have on our website, at the top there's a box that you can check off that says I request a transfer to the Superior Court or something like that. Request for a jury trial, whatever it says. So I was thinking, because it was never established that there was a deadline for filing an answer, and really might not be appropriate to proceed with a merits hearing without an answer anyway, why don't we just extend the deadline for filing an answer and filing a request for Superior Court transfer, then you can check that box and it will at least get put on the track that you want it. I think you even cited Article 20. So if that's truly the way you want to go, I can do that, and then whatever review you need to have of, your claim under Article 3 or anything like that could be heard in the Superior Court in one shot.
Thank you, Your Honor.
And I'll just say one more.
Yes.
Yeah,
Well, Ed, I have questions to respond to it.
sure, and I'll just add to that though, if I were to start passing on, legal questions in this case, it might be that it's considered that your Article 20 right is waived. And then I wouldn't be able to transfer the case to Superior Court after. I haven't really thought that one through completely, but generally, because ordinarily you have like 30 days from the date of filing, there's a deadline that's very close to the return date that you have to request a transfer to the Superior Court. So we're well beyond that. I'm willing to extend it now, but if I'm asked to rule on motions and things like that and do more substantive things in this court, it might be that we pass. There might be an objection at that point to transferring to the Superior Court, and then we might be stuck here. That's itself.
So thank you for that consideration, Your Honor. I actually did some research, and this court can hear jury trials. It's under 490 F15. Referees can hear jury trials.
490 F what?
F15.
So
So the 490. Yep, I have it listed here, and I can even put it in writing. So we got 490 is the circuit court, which was created in 2011. We have 491, which is the Superior Court, and in the circuit court, F17, existing procedure carries through. It's similar to this, the family division. So in 491:13, trial by a justice or justices unless objects, and then if you go back, then you have Article 20 with the jury right.
So 490 F15, referring to referees, and just so there's no confusion, I'm not a referee.
Yes, Your Honor. I actually looked you up. You've had some cases, and I appreciate your candor.
And then you said 491.
F13. So there's 490 F15 and 17. 17 is existing procedures. Then you're going to Superior 491, which used to be basically the Supreme Court of Appeals until the 60s. You have 491:13, trial by justices unless objects. So I could object. I don't want it to leave this court now, because upon receipt of this evidence, I look at a contract and it says that if it leaves this court, either party can go, force arbitration. I want to deal with this matter as quick as possible, but there's just so much going on, and that's what I talked to opposing counsel about, is if we could continue this hearing. I need you to look and see how much you can, from the information that I gave you, or if I file another motion, but in regards to the fraud and judicial and professional misconduct described in there.
So you want to keep it here, you want to continue it, and you want me to rule on your Article 3 claim, essentially the theory of Article 3 that is an individual right or has some individual application. And you do not want to go to the Superior Court. Is that, am I hearing
Correct, but also there is a report of judicial and professional misconduct. So I'm looking for some answers from the court, Your Honor.
Well, so the way this case is postured, there's only one form of relief that I'm considering on a final basis for a final judgment, which is the Discover Bank's request for a judgment in the amount of $8,500 some odd dollars.
Right.
Your report of judicial misconduct and stuff, I can construe as being perhaps a basis for me to entertain your theory that Article 3 makes it such that you're, not a proper defendant. But I can't issue affirmative orders granting relief. I can't make a ruling that you have been the victim of fraud and that other judges have committed, and an attorney have committed misconduct, and grant you affirmative relief on those claims.
And I understand that, Your Honor. What I'm referring to is Rule 38, 2.15, which requires a very low bar, any information, for instance, like the police information, so it's suspicion. So what I reported is a signed affidavits, and that I need the other cases to be reformed. I haven't seen my kids in over 3 years on fraudulent DVs. When I brought it up at the hearings in this court, they would not let me question witnesses, and they continued the fraud. So I'm also putting this in the Supreme Court. The basis of justice.
So you just want me to make a referral to the Judicial Conduct Commission and the Attorney Discipline Office?
As you see fit, because I don't have to do that per 311:6, which you are attorney.
I'm not an attorney.
You were attorney.
I was an attorney, yes.
So-
I just want to make it clear, I can't represent people anymore.
Oh, I'm not asking you to.
Okay.
It's the foundation of justice. We need to get these issues handled as soon as possible because life is fleeting. That can never be gotten back with any money. It is stopping my life and abusing my children. This is of the highest magnitude. So based on what I sent you, that's information. You have a duty. I can't make you do anything. You've been nothing but kind and generous and thoughtful. So you have to make a decision based upon that. Read Rule 38. You make your decision. I've reported this to the administrative courts, and that's your duty as you see fit. And then I could object with that, but the way you've treated me has been nothing but fair, so it's up to your conclusion.
Okay, all right, so I will consider that. I'll make orders. Sounds like we're going to continue this for another day by agreement. And I'll also just make clear the caveat, my jurisdiction in a district division small claims case is very narrow. And I wouldn't be able to issue affirmative relief that would affect custody orders or your ability to see your children. That would have to be dealt. I suppose it can be me, but it would be me in a different docket with different parties in front of me, different form of notice. But different courtroom downstairs, I suppose.
You would think about it, like you would have to think, I say that you are still under your 311:6 oath, even though you're not a practicing attorney. I'm saying that doesn't mean it's
I
true.
have a different oath that's very similar.
92:2, and so on. So then review Rule 38, make the decision that's in your heart or with your honor, right? And then if there's anything to hear from opposing counsel, again, he's been nothing but a gentleman. He mentioned 180 days. We could bring it back forward, but we'll be in contact, and if it's okay with the
180 days would be fine, Your Honor.
All right, 180 days for you two to chat it out. I'll come up with an order based on the motion to continue or the relief requested within the motion style, motion to continue, and then We'll just have another merits hearing down the line. If you guys don't need it, then let us know. We'll go from there.
Thank you, Your Honor.
All right,
Thank you, Your Honor.
thank you both.